Hello, I'm Nicole Ware, Associate State Director of Outreach and Advocacy for AARP Ohio, and welcome to Guardianships and How to Avoid Them. I lead the community outreach and advocacy efforts in Cincinnati and Ohio and Southwest Ohio, but I know that many of you are joining us from across the country today. It's always fun to see where you're joining us from, so in chat, tell us what city and state you're joining us from today. Atlanta. Welcome, Karen. Thank you. Crestone, Colorado. Cleveland. Oh, it's going fast now. Mesa, Arizona. Mason, Upper Arlington, Lakewood. Huntington Beach, California. Hello, Yellow Spring. Las Vegas. Look at that. Colorado. Well, it's so great to see where you all are from. Clearly, this topic has resonated with you. And we're going to get into that in just a few moments. But here with us today is Sandra, one of our fantastic AARP volunteers, and she is not only going to share with you how to make the most of today's session, she's also going to share some tips and resources about how to help family caregivers, and I'll be back with you shortly. Sandy?
Hello, welcome everyone. My name is Sandra, and I'm an AARP volunteer in Cincinnati, Ohio. I'm pleased to volunteer with AARP to bring you engaging events like the one you're viewing right now. Before we begin, I'd like to walk you through how to engage with us during our time together. Move your mouse or cursor across the bottom of the screen, and you will see the Q&A icon. To ask questions during the Q&A portion of the event, click on the Q&A icon and put your questions there. This will help us access your questions quickly without scrolling through the comments. Of course, to make a comment, continue to put those in the chat. We also are recording this presentation. In the coming days, you'll be able to view it on AARP Ohio's YouTube page. We'll put that link in the chat for you at www.youtube.com/@AARP Ohio. AARP has always been working to promote the health and well-being of older Americans for 65 years. We recognize that many of you joining us today are or will be the family caregiver for your parent, a spouse, a sibling, or loved one. As the holiday approaches, it can be very stressful for many, including family caregivers. Nearly 7 in 10 caregivers say that it's emotionally stressful to be caregiving and going through the holiday at the same time. So AARP wants to help caregivers navigate this season with tips and resources to help you get the most out of this holiday season. In AARP's recent report, A Look at the U.S. Caregivers' Mental Health, it asked people about the effect that caregiving has had on their physical and emotional health, their levels of stress, and the ways in which they manage the pressure. While most people said that they were getting an adequate amount of support from friends and family, it did not alleviate some of the strain that comes with caregiving. In fact, more than half said caregiving increased their level of stress, worry, and concern for the future and anxiety. So we want to share some tips and resources we hope you will find helpful. Consider listening to your favorite music, perhaps even create a playlist to ease stress. AARP's Global Council on Brain Health issued a report on the powerful potential music has to improve your mental well-being and your brain health. You can read this report at aarp.org/brain health. Additionally, many caregivers manage stress by talking to a friend or family member, exercising, or participating in other forms of physical activity. Pickleball, anyone? Visit aarp.org/caregiving, where you can read the AARP report, a look at U.S. caregivers' mental health, as well as finding additional resources and support. And feel free to call us at our resource line at 1-877-333-5885. Agents are available to take your calls Monday through Friday, 8 a.m. to 8 p.m. Eastern. The support is also available in Spanish at 1-888-971-2013. Again, family caregivers can find support at aarp.org/caregiving. Now, it is my pleasure to introduce you to today's speaker. Remember, you'll have an opportunity to ask Marian questions later in the program. Click on the Q&A icon to type your questions there. Now, I'll introduce Marian Sheline. Marian is a managing attorney at Pro Seniors, Inc., a legal assistance nonprofit serving older adults in Ohio. Marian has been with Pro Seniors since 2003 and has presented seminars on guardianships, advanced directives, nursing home rights, and estate planning, Medicaid, grandparent rights, and consumer debtor rights. She has experience with probate, real estate, and bankruptcy. Marian, welcome.
Thank you, Sandy, and good evening to everyone. Let me share my screen so that you see our presentation. All right. There we go. Okay, so thank you again, Sandy. And as she indicated, I am the managing attorney at Pro Seniors. Pro Seniors is a nonprofit organization located in Cincinnati, Ohio. And one of the services we provide is a free legal helpline. Any senior 60 or older, or a caregiver on behalf of that senior, can call and get free legal advice on any issue. The senior must only be over 60 and live in Ohio. The process is just call that 1-800 number you see on your screen and probably post it in the chat. Our intake will take some basic demographic information, schedule you with a telephone appointment when the attorney will call you to discuss your legal issue. One of the topics that we frequently have questions about on our helpline is guardianships. So I'm going to spend the next 50 minutes or so giving you background information on what a guardianship is and what are the alternatives. As Sandy was talking about stress for caregivers, guardianships are very stressful for both caregivers and the senior. So we're going to talk about what's really a guardianship, what's involved, and are there ways that we can avoid that? As Sandy indicated, feel free as we go along, if you have questions, to put those in the Q&A. And I believe we will have about 15 minutes at the end with Nicole to go through some of those questions. All right, so let's get started. First question is, of course, what is a guardianship? Can I simply sign a paper that says my daughter is my guardian? And the answer is no. A guardianship is a court proceeding, which is specifically created to provide continuing care or supervision for the person and or the estate of the ward. The ward being the senior who the court has basically made a ward of the state. That's what the guardianship process does. Now, I should preface, I know we have some attendees outside of the state of Ohio. All of my slides relate to Ohio law, okay? If you're, of course, a caregiver with an Ohio resident, it's all applicable, but with regard to specifics as to your state, you would need to check with a local attorney regarding that process, okay? But in Ohio, as I said, is a court proceeding, the end of which means that the senior becomes the ward of the court. So, who needs a guardian? Note the word needs a guardian. Okay, the guardian is for an incompetent person. In the law, we have definitions for everything. And in this case, a legally incompetent person is defined as one who is so mentally impaired that he cannot take proper care of himself, his property, or those for whom he is legally responsible. So this is the initial determination that has to be made at a court proceeding, which is the probate court who has that jurisdiction. So, are there different types of guardianships that the court can set up? And the answer is yes, depending on the situation. Generally, there are two types. One is guardian of person, who is responsible for the care and custody of the ward. And there is the second one is the guardian of the estate, who is responsible for the ward's property and finances. These are can be the same person, but they can also be different individuals. Now, the court could also appoint a more limited guardianship, i.e. something for a specific type of situation. The example in our case would be someone who needs what we call a QIT. So someone is applying for Medicaid, they're in a nursing home, their income is too high. So what we call a qualified income trust must be established. And is there a need to set up a full guardianship of the estate just for that purpose? And the answer is no. The court could authorize someone just be guardian to set up the qualified income trust. However, the determination, the beginning still has to be that the proposed ward be determined legally incompetent. Only after that determination does the court gain authority over the individual. With regard to emergency guardianships, yes, there is a provision for such a situation. Again, it is going to be even more limited because there has to be a determination that there is an immediate action, i.e. something has to be determined before the hearing on a regular guardianship, and it's needed only to prevent significant injury to the ward. Then there would have to be a hearing within 3 days and could be extended for 30 days, again, merely to allow the time for a full guardianship proceeding. So how do we start one? Well, a petition has to be filed with the probate court, and the individual who's filing it is filing a petition in the county where the senior is located or the proposed ward lives, and is going to include basic information regarding the ward, the property owned by the ward, but also the reasons why the applicant thinks the ward is legally competent. The application is going to require the listing of all the next of kin of the ward and something about the guardian. There's going to be an affidavit that the guardian has never been charged with or convicted of a theft or domestic violence or sexual violence or substance abuse issues, etc. Then there has to be a doctor's statement. Is also required discussing the ward's mental capacity. If there's an estate or property, the guardian may have to post a bond to cover their management of any property. So what's the process? The probate court, once an application is filed, is going to serve the proposed ward with the notice of the guardian's application, and it's going to include a time and place of the hearing that will be held on that application. How that is done is that a court-appointed investigator will go out to visit the proposed ward. The individual will give them the paperwork, will explain to them what this application is, i.e. that the proposed guardian is saying that the individual is incompetent and needs a guardian. And the investigator is to file an independent report, which includes a brief description of their physical and mental condition, whether they need a guardian, or is there a least restrictive alternative. Always one of the goals for the court has to be to honor the least restrictive alternative, which is going to be some of those alternatives that we talk about in the second section, and whether the person needs an attorney to be appointed. In addition, the court can appoint a physician or another professional to examine the ward and to render an opinion. Then at the hearing, the guardian, the applicant, must establish by clear and convincing evidence that the ward is incapable of caring for himself or herself or her estate. Then only if the guardian meets that burden of proof will the court may appoint the guardian. And I should mention clear and convincing evidence. What that means legally is that in civil matters, we have what we call preponderance of the evidence, which is basically a little more than 50%. And in criminal, we have beyond reasonable doubt. Clear and convincing evidence would fall somewhere in between. So it is a higher standard than just a civil 51%. The notice of the petition and the hearing must be served on the ward at least 7 days before the hearing, and must tell him he has certain rights. He has the right to be at the hearing. He has a right to contest the petition. He has the right to be represented by an attorney. He has the right to choose a friend or family member to be present. He has the right to introduce evidence from his own evaluation. And even if he is indigent or can't afford it, an attorney and an independent expert evaluator can be provided at court expense. So the ward is going to have the right to appear at that hearing and say to the court, I want an attorney. I do not want to be a ward and I can manage myself. Even on an appeal. So this decision could be appealed to the Court of Appeals. And if the ward is indigent, they are still going to be entitled to have an attorney appointed, as well as the paperwork for the appeal prepared at court expense. So who could be the guardian? And any adult can be appointed, but they are to be an Ohio resident. Now the ward may have named the guardian in a writing that we'll discuss about later, which could waive the Ohio residency. But generally, especially with property, if there's a guardian of the estate, the court's got the discretion and frequently will not appoint someone other than an Ohio resident. The reason being is that the court is going to be the superior guardian, and the court is designating this individual basically to carry out the court's duties towards the ward, who is, as I said, a ward of the state of Ohio at that point. If a guardian moves out of the state of Ohio, he can be removed. Now, if the applicant is married, the spouse is given preference. And as we'll indicate, designating guardians in some documents later on, those will also be given preference. Okay, there are additional educational requirements for an individual who wants to be a guardian. at the time of the appointment or within 6 months. There is a 6-hour guardianship fundamental course that every guardian must take that basically educates them on how a guardianship is established, what are the duties of the guardian, the record keeping and reporting duties of a guardian, and additional topics as the court devises. In addition, every year there is a 3-hour continuing education course that all guardians are to take. So what are the duties of the guardian? Okay, and they are to the fiduciary of the ward. What are they to do? They are to act in the ward's best interests. But note that they are to protect and control the ward. And that's sort of a key terminology. They are to control the ward, which means they are responsible for the daily maintenance. It is not paid out of their funds. It is paid from the ward's funds. And they are to authorize healthcare decisions unless the ward or a third party objects to the court. In general, the guardian is going to make the decisions unless an objection is filed with the court, who can always overrule their decision, especially with regard to the person. When a guardian of the estate is to handle financial matters, they are going to be authorized to sign contracts only with probate court approval. They have to file an inventory. They must get approval from the court for every expenditure. They have to annually file reports, which itemizes every purchase and including receipts, as well as bank account statements, basically accounting to where the property is. What about the duties for reporting with regard to guardian of the person? Every 2 years, the guardian is to file a status report, including the number of times the guardian has had contact, what that nature of that contact was, what was the last date, any major changes in the ward's physical or mental condition, whether the guardian believes it is necessary to continue the guardianship, and again, a statement from the licensed physician done within the last 3 months, whether or not the guardianship should be continued. Now, recognizing that, again, the power and the responsibility of guardianships, the Supreme Court has come up with basic rules to also govern how the guardian should perform its duties. So, for instance, the guardian is to act in the manner above reproach, not financially exploit the ward, exercise due diligence with regard to making decisions, and communicate with the ward and be fully informed of what are the implications of their decisions. They are always to consider the least restrictive alternative for placement, but the guardian makes that decision unless the probate court says otherwise. Again, so if the individual is able to live at home, then the guardian should facilitate that living, as opposed to removing them from their home and placing them in a nursing home. Does that mean the guardians cannot or do not have the authority to remove someone to the nursing home? No, they can. They have that authority. This, however, is where they're supposed to look at the least restrictive alternative. They're to engage in person-centered planning, which focuses on the wishes and needs of the ward to reach their full potential. They should balance maximum independence with their best interest. They should foster and encourage their positive relationships, unless substantially harmful to the ward, and they should be prepared to explain the reasons a particular relationship is severed and not in the ward's best interest. However, note that effectively says that the guardian has the authority to terminate visitation with friends and family If in the guardian's opinion, this is harmful to the ward. The remedy then, of course, is for someone to file a complaint or objection with the court to try to overrule that decision. The guardian is to assess the needs for additional services, notify the court if the ward's level of care is not being met, document all complaints made by the ward, and determine whether those complaints should be reported to court. Of course, if the complaints are about the guardian, that does certainly raise issues. The ward, others can file complaints with the court, who is to refer that back to the guardian and get their response. What else are they to do? They're to monitor, to coordinate services and benefits. A guardian's to make sure that the benefits to the is being provided to the ward, including having regular contact with all service providers, assessing services to determine if they're appropriate and should be continued, maintain eligibility for benefits. And if you've got two different guardians, one for the person, one for the estate, they should talk to each other. All right. With regard to extraordinary medical decisions, again, they should seek out expert advice, and they should strive to honor the ward's preferences and belief systems. They have the duty to keep the ward's personal financial information confidential, and they should report to the court any issues regarding allegations of abuse, neglect, or exploitation. Now, they are not the alter ego of the ward. Okay, so that just because you're a guardian doesn't mean you can do everything. As we said frequently, we've highlighted some of those. You do have to get approval from the court. Guardianship can be terminated. The ward or anyone on his behalf may petition the court in writing to terminate the guardianship. The court is to have a hearing to determine whether a guardianship should continue. And at that hearing, the guardian is to prove again that the ward is not capable of caring for himself or managing his affairs, again, by clear and convincing evidence. If the ward moves outside of the state, then the guardian in the new state can apply to the court to have the Ohio guardian removed. Effectively, the Ohio court no longer has jurisdiction if they are not a resident of Ohio. And once a guardianship is terminated, again, the guardian is to file a final account, including all expenditures, itemizing all purchases, and showing the balance and where the additional property has gone. What are the effects on the ward? We sort of discussed that, but it is clear that a guardianship restricts the ward's right to self-determination. They are unable to perform any act that conflicts with the guardian's authority. They cannot enter into a contract. They cannot sell. They cannot give, convey, or encumber their property unless the guardian approves it. Effectively, the guardian has to do it. They lose possession and control of their property. They cannot sue. They cannot choose where to live. All of these decisions are now in the hands of the guardian. There are one exception, and that is with regard to making a will. The guardian does not have the authority to change a ward's wills or to make wills or testamentary dispositions for the guardian's property. I'm sorry, the ward's property. Okay. There is another probate process called a conservatorship. The conservatorship is a voluntary petition made by the senior, where they request the court to appoint a conservator to manage their property. This will only continue so long as the ward desires it, and the conservator is going to be governed with the same rules as a guardian with regard to probate court supervision and filing accountings, getting approval for expenditures. And at any time that the ward no longer wants the conservatorship, it will terminate upon the ward's request. So this is basically what we've talked about as to the extreme method of guardianship and getting the court involved. How do we avoid that process? And other than a conservatorship, which is still in the probate process, and that's going to be what we talk about as to alternatives to guardianships. So you, during any period that you are competent, can authorize another to make decisions for you, and that authority can continue at any time that you are not able to do so for yourself. This breaks into two different categories, sort of like we were talking about guardians of the person, guardians of the ward, or I'm sorry, guardians of the estate. So legal documents that you can prepare first over your person, which is a healthcare power of attorney, and the second over your property, which is a financial power of attorney. And we're going to spend some time discussing each of these separate documents because they're set up differently with different criteria. So let's start with the healthcare power of attorney. And I always urge you, everyone on this call, you should have one. Right? This document is signed by you appointing another to make healthcare decisions for you if you have lost the capacity to make informed healthcare decisions for yourself. It only goes into effect when you have lost that. But you are now designating a trusted individual to make decisions as you would and in your best interest, only when you are deemed incapacitated or unable to do so for yourself. How does that unable to make that decision get triggered? Basically, the attending physician, your doctor, indicates that you've lost the capacity to make an informed healthcare decision. So how do we make them? They are standardized forms. I will show you in a little bit where you can find those forms. But generally speaking, you're going to put in the name, address, phone number of an agent and alternates. You can designate alternates if you cannot reach the first one, that someone could reach the next on the list. Okay. But that's why we have the address and phone numbers on there, so that if it's needed, that individual can be reached. You have to sign it. You have to be an adult. You have to be of sound mind. Generally speaking, you understand what this document is and that you are granting this authority to a third party. Key is how it is signed. Your signature must either be notarized or witnessed by two adults. Does not need both, one or the other. If you're having it witnessed by two adults, there are additional limitations. The witnesses cannot be related by blood, marriage, or adoption. They cannot be the agent or alternate agent. They cannot be your doctor, and they cannot be the administrator of a nursing facility where you reside. The state of Ohio basically considers these individuals to have a conflict of interest, and they don't want someone with conflict to be documenting that you are capable of signing these documents. Who could be the agent? Any adult, except cannot be your doctor, cannot be the administrator of a nursing home in which you reside, cannot be an employee or agent of either the doctor or the nursing home, unless the employee is related by blood, marriage, or adoption. Again, conflict of interest for these individuals to serve as your agent. That conflict of interest is removed when it is related to you. What is their authority? They have the authority to make any healthcare decision, including, as we will discuss briefly, the termination of life support. and will have access to your medical records and can choose your medical providers, can hire and fire doctors, nurses, nursing homes, can authorize medical treatment, all the same as you could have done for yourself. There are duties and some limitations. They are to make the same healthcare decision that you would if you were able to make those decisions. Only if they don't know what that decision is, can they decide based on what's your best interest. So for an example, let's say you started chemotherapy treatment, and because of the chemotherapy treatment, you lose the capacity to make medical decisions. Your agent says, I don't believe in chemotherapy treatment, stop it. The healthcare power of attorney does not give your daughter that authority. Only if that treatment that you have authorized is no longer of benefit to you can she terminate something that you have already started and that you have authorized. If the agent doesn't know what decisions that you would make, then they are to decide in your best interest. That being obviously conversation with those agents. What are your wishes? What are your decisions with regard to your medical care? When there's a conflict between the agent and the document, the healthcare power of attorney document itself, the document controls. Though there are spaces on these forms that allow you to limit their authority. In private practice, I represented individuals who were Jehovah's Witnesses. They added the limitation that the healthcare power of attorney had no authority to give them blood transfusions or blood products. You have an agent who is not Jehovah's Witness and says, I don't believe in that, give it to them. The answer is going to be no, because the power of attorney document itself limits their authority. They can refuse to accept the appointment. They don't want to be your agent. That's fine. That's why we designate alternates. Now, in the healthcare power of attorney, I sort of hinted at this, but basically in a healthcare power of attorney, financial power of attorney as well, you can designate who you would want the court to appoint as your guardian of the person, of the estate, or both. That is simply designating your wish. That does not make them your guardian. Okay, so you're just saying to the court, if a guardian is ever needed, here's the person I would prefer to be my guardian. And if that's appropriate, the court is going to honor that determination. But to be appointed a guardian, you still must go through that court process. What if a guardian is appointed and it's different than who you've designated as the agent in your healthcare power of attorney? Who continues to make medical decisions? And the answer is that the healthcare power of attorney remains in effect and will have the authority to make those medical decisions until and unless the court finds that it is in best interest of the ward to terminate that healthcare power of attorney after notice to the agent. So the court has to specifically find that that agent is no longer acting in your best interest before that authority is terminated. Okay, one exception, as we said, the healthcare power of attorney is only effective in the situation that you are unable to make medical decisions for yourself. The exception to that is that the agent can have access to your medical records. It is a HIPAA authorization. Can it be revoked? That is the other beauty of these documents in the first place. You can change your mind at any time and in any form. You can revoke it by simply saying, I revoke it. You can do it in a writing saying, I revoke it. You can write on it revoked. Okay? You can rip it up. The only key is obviously in all of these situations, Your doctor must know about its existence and about the revocation. You are to, when you've done one of these, you need to make copies. Copies are as good as the original. And you need to give these to your doctors, to your agents, to the hospital anytime you would go there. But also, if you revoke it, then they need to know about the changes or the revocation. Must they honor a healthcare power of attorney? The answer is no. But if they refuse to do so, they are to remove themselves and allow you to be transferred to a provider who will honor them. With regard to termination of life support, there is a specific authorization in the healthcare power of attorney that you can choose to say they can make that determination. However, they never have the authority to terminate pain medication, or any treatment which provides you any kind of comfort or pain relief. Those can never be withdrawn. What about the termination of life support, specifically artificially given food and water? The answer is that you need 2 doctors. You have to be in a terminal condition, or what we call a permanently unconscious state. And you have to authorize it specifically with regard to the withdrawal of artificial nutrition and hydration. On the form, there's a specific authorization that requires a separate signature. And 2 doctors must determine that the artificially given food and water no longer provides you comfort or relieve your pain before it can be removed. So it requires 2 doctors to determine you're in a permanently unconscious state or terminal condition, and that the withdrawal will not cause you remove your comfort or pain. Is a healthcare power of attorney created in other states valid in Ohio and vice versa? Generally speaking, yes. However, if it's a permanent move, we generally suggest that you have it done in the state, because each state has their own form and their own format. And Ohio providers are going to be the most familiar with our forms. They do not expire, and copies are as valid as the original. What happens if you do not have a healthcare power of attorney and you are in a permanently unconscious state or in a terminal condition, and you are not able to make the determination with regard to termination of life support? If you're in a terminal condition, then there is a group of relatives who can all agree, and the majority agree to terminate it. Then that can be done. Of course, that leads you into the battle in the hallway of the hospital, which this document will avoid and is better to do. If it is a permanently unconscious state under Ohio law, the attending physician must wait 12 months before the relatives can consent to the withdrawal of life support, and you have to seek a court order. So on our website, proseniors.org, you can see that we do have some forms. You go to our website, you click resources. When you click resources, you will see one that says legal forms. You click legal forms, it will take you to our toolkits. Under self-help legal toolkits, you click that, and you'll see advanced directives. And under this toolkit, there are the forms and documents as to what they mean, what are pamphlets. So let's talk briefly about our financial powers of attorney. Okay. So this is to give someone the authority to manage your finances. Different rules than the healthcare power of attorney. It will give an agent broad range of financial power It has to be recorded if it's used to buy or sell a house, and it needs to be acknowledged in front of a notary if you're going to also involve the sale of personal property, i.e. a car. You're going to have a your financial power of attorney notarized before the BMV will transfer the title. What is durable? This becomes a question. It used to be our healthcare power of attorney said durable power of attorney for healthcare. Durable is a legal term that requires that the document itself say this power of attorney shall not be affected by the disability of the principal or lapse of time. If that language is in the financial power of attorney, it will continue to be in effect even after you become incapacitated or incompetent. How can you draft a financial power of attorney? It can be as drawn as generally or specifically as you wish. So for instance, before in Ohio, we could mail in our tags. If you had to go down to the BMV to get your license tag and you were getting it for the car title in your spouse's name, they would hand you a form for your spouse to sign. That was a power of attorney authorizing you to purchase license tags for him or her. Okay, bank account. You can, for instance, add your son or daughter simply as an agent on your bank account. This simply authorizes him or her to sign checks for you. This is different than a joint owner. It is simply designating them as an agent, effectively a power of attorney just over that bank account. Or you can have a much more broad financial power of attorney document that covers everything: life insurance, real estate, stocks, bonds, operating businesses, handling claims in court, etc. Unlike your healthcare power of attorney, your financial power of attorney takes effect immediately upon its signing and handing it to the agent. Therefore, you should take care and not just automatically hand this to a son or daughter until such time as you're ready for them to manage your finances. What is the agent's role? Again, contrary to the guardian situation where they have the authority as to managing your finances, you maintain the role of effectively the employer over the attorney, in fact, over the one who has POA. You are entitled to an explanation and accountings at any time from the attorney. In fact, you still have the authority over your own property to the same extent as before the document was signed. The agent is effectively your employee and is answerable to you. Revocation, it can be canceled at any time. Simple writing, say I revoke it, is sufficient. However, again, if it's been recorded, then you need to record the revocation. And you must provide that revocation both to the agent and to all financial institutions that have your power of attorney to begin with. They will continue to operate based on that POA unless you have notified them that it is no longer in effect. What about after death? A power of attorney is only valid for the principal's lifetime and terminates upon his death. Again, with regard to reforms, if you go to proseniors.org, resources, legal toolkits, under those self-help toolkits, again, there is a provision for a standardized form for financial power of attorney. Generally speaking, you can also reach out to our helpline to get advice with regard to your specific situation in filling out the forms, including a financial power of attorney. Now, what about a living trust? A living trust is another way of managing property, but it is limited to the property that is in the trust. So if you create a trust that does not give them unfettered authority over property in your name, effectively a trust is like setting up a small corporation that you fund, and you appoint someone like the trustee to manage that in accordance with that trust document. If the property is not, however, in the trust, trustee has no authority over it. So just quickly again, before we get to our questions, here is our senior legal helpline. It is preset 30-minute appointments over the phone. You would call our number, 1-800-488-6070. Our intake will guide you through some demographic information they do need to ask, and then we'll schedule you with an appointment with one of our helpline attorneys to talk about your legal question. And again, they are scheduling about a week or less out with regard to those appointments. We also, just to mention, is a Mid-American Pension Rights Project. This could be questions about pensions specifically. They have a special number. As we all know, pensions can be a much more specialized area of law. And then just a brief mention. Okay. Ohio Senior Medicare Patrol. This is a volunteer group, sort of like AARP Ohio, but they assist on identifying Medicare frauds and scams to educate other Medicare recipients and how to do that. So they have a separate number, 1-800-293-4767. And I think we are ready for questions.
Okay, great. Well, thank you, Miriam. That was very helpful. We do have some questions coming in for you. And again, if you all have questions for Miriam or myself, please go ahead and put those in the Q&A icon. So we have a couple questions that are from other states. And so wondering if you have a resource for anywhere outside of Ohio. So the first question is, are Ohio guardianship laws similar or the same as those for Colorado? Can you speak to that at all?
And I really can't. Most states are similar. I will tell you with regard to needing a court process, for instance, and having due process rights, I think those are going to be similar. Those do come, constitutional basis. So yes, an individual is going to be receive notice, going to have a right to an attorney, et cetera. But I do not know the specifics with regard to Colorado law. So I would recommend, and maybe Google, and some states also have helplines. About, I think, 19 of the states have their own helpline. I do not know off the top of my head whether Colorado does. So you might want to Google that to see if there's a legal helpline in Colorado.
Is there a national nonprofit that people outside of Ohio could refer to as a resource, or should they just Google, guardianship, their state nonprofit assistance?
Yeah, that's a very good question. I probably have to give you a link or something. Yeah, I mean, there is a national group of senior hotlines or senior helplines. But I don't know, like, if they have a website or this is just the group of all the different helplines that work together. This has not been, nationally funded. And it's pretty much been funded privately, as ours has been, started by groups like AARP, who started ours way back in 1975. And so it is pretty much by state and state funding. So I do not know if there's like a national website. It's probably going to be Google your area.
Okay. So Barbara is asking, she says she needs a referral to an expert who can reassess a family member in order to determine if they're no longer incapable of handling their personal and financial affairs. How do they relocate such a professional? The family member is in Ohio. Does the expert need to be in Ohio as well?
I would say probably yes. okay? Because they tend to look at Ohio standard of care. And if the resident is already in Ohio, that should suffice. And I think you said they're already in Ohio, and I'm not sure if they're relocating to another state, which would be filing a new application in that other state. And I would guess that they would accept Ohio's evaluation initially. But generally for Ohio, our Ohio courts are going to look for Ohio providers because they are looking at someone like the treating physician, especially to terminate a guardianship.
Okay, so Yvonne is asking, is a guardianship needed if a trust, power of attorney, or healthcare power of attorney are completed by the ward prior to incompetence?
No, it is not. That is precisely exactly what we've been discussing. If you have these legal documents in place, there really should be no reason for guardianship. The only reason then for it to occur is going to be, let's say the agents are somehow financially or physically abusing or something to protect the individual in that situation. But if the senior has provided for this with competent agents who are working, following their fiduciary duties, there is really no need to do a guardianship.
Okay, great. So Stephen has a question. I'm going to try my best to understand it. Feel free, Stephen, to put the question again in the Q&A. He's asking, where's the due process when a doctor declares one incapacitated under the healthcare power of attorney?
So there again, it's a question of you have authorized someone to make medical decisions in the event a doctor makes that determination. So with regard to healthcare power of attorney, you have chosen the agent in that situation. That's why that, a doctor would make that determination saying it's not really it's not a legal determination and they're not necessarily stripping you of your rights because you have authorized this person to act on your behalf. So the question then, would become if you've terminated, that healthcare power of attorney because you don't want that, and then will others honor it? So as a result, now they put you into a guardianship proceeding where you can get, fight that out in probate court.
Okay.
So
Arlene is asking, she says she is the power of attorney for her mom. Please explain if she needs a separate financial power of attorney.
Okay. So a financial power of attorney is going to cover property. So if she owns real estate, if she owns life insurance, any kind of property that she owns, that would be where you need a financial power of attorney. Your healthcare power of attorney is going to allow you to make all medical decisions for her. Okay. If you are, as we were discussed, a financial power of attorney, hence an agent on her bank account, and that's all she has, so that you have access to her assets that way, then that's all you need.
Okay, great. Anne is asking, is the county required to provide both a guardian and an attorney for a ward?
Generally speaking, the probate court does not provide a guardian because who is going to appoint that guardianship? If someone files the application, there may be a indigent fund for guardian of the person. As to the attorney, if the ward goes to the hearing and says, I want an attorney, the court must provide it at court expense.
Okay. So earlier you were saying that the power of attorney is only in effect during the ward's lifetime. Sarah is asking, what happens after they die if you have guardianship over them? So what happens after they die?
Okay. So if you have a guardianship, your guardianship is going to be terminated at death as well. You are going to have to file what we call a final report or final account. That's going to be a reason to terminate the guardianship. But the court's going to want to know, okay, where's the property, et cetera. If there is a guardian of the estate, then you're going to have to open up an estate in probate and have someone appointed the executor or the administrator to take over the management of the property after the individual's death. But if there's no property and you're just guardian of the person, then you're simply notifying the court and you're filing basically a final report, at which point the court is going to discharge you from those responsibilities.
Okay. So Mark has a question. Let's see if I can understand this. He said, you made a comment on the financial power of attorney as being named an agent. Does that mean that if the parent asks you to be an agent to handle financial matters, is the power of attorney will authorize you at that point?
It cannot be oral. No, it has to be in writing. So they have to sign a document, power of attorney document, that designates you as the agent effectively, or what we call an attorney in fact. But under law, basically, it's an agent to act on their behalf. So there has to be something in writing, whether it be a specific property, like we said, a bank account, you're going to the bank and you're filling out a form, you're signing for them to be put on as agent. They have their own form. They require you and the parent to sign. It is the same with any property or a general power of attorney. It has to be something in writing.
Okay. Colleen is asking, so if you have a financial power of attorney, is that still in effect after death? I think you just answered that. To manage mortgage, bank accounts, etc.
So yeah, after death, your power of attorney is no longer valid. Okay, at that point, then you've moved into what we call a probate estate situation, where the court has to take control of the assets, pay the bills, and distribute whatever's left. So in that situation, you'd have to either open up an estate or depending on what you've set up when we talk about avoiding probate through survivorship or other kinds of designated documents, which I think we talked about at the last seminar, right? So generally speaking, no, you as guardian, you will not have authority, and as power of attorney, you will not have authority to be writing checks from the decedent's account.
Okay. I have an anonymous question. She says she is her disabled daughter's only family. She is her healthcare power of attorney, and she has a trust. She lives in assisted living and still needs some help from her, the mom. They are in Ohio. What happens when the mom, dies?
So if there is an alternate designated, then the alternate can take over. Okay. And that alternate does not have to be, a relative. But yes, if she needs assistance, there are sources through your area agency on aging, for instance, or other sources to get third parties to help her. You can be designated, maybe representative payee, something like that, to assist with her finances. So those are some sort of other options as opposed to a guardianship. If she is able, as you said, competent and able, but needs assistance, she may be able to designate someone still to make those decisions or to take that on.
So Barbara's, she says she's not relocating, but she is seeking an Ohio professional to reassess capability. Is there a resource you can refer her to?
Generally speaking, when we talk about assessing capabilities, it's usually, a provider here in Ohio. There isn't like a group of evaluators. Okay. The court may appoint someone, but that's only after an application has already been filed. So yeah, that's more of a medical decision rather than a legal decision.
Okay.
Okay,
so Stephen is asking, does Ohio use supported decision-making as an alternative to guardianship?
The only quote supported decision-making that we have is what we've already talked about, which is your powers of attorney, healthcare and financial powers of attorney. We don't have a separate legal process for supported decision-making.
Okay, so I don't want to answer this question for you. Donald is asking, do you recommend having an alternate agent?
Absolutely, whenever possible. It's a little closer, obviously, with financial, because you are much more concerned about potential exploitation, but it can be done on a financial power of attorney. But on healthcare power of attorneys, absolutely.
Okay, and when should an alternate agent become involved?
And that's a little different depending on the situation as well. If there's a healthcare power of attorney, generally speaking, the agent is in charge until such time as they are unable or unwilling to do so. Frequently with like a healthcare power of attorney, unable or unwilling may be that they're unable to reach the individual to make a critical decision, and so they will go to an alternate. With regard to finances, it tends to be more of a, I'm not going to do it.
Okay.
With regard to the agent.
Okay. This is an anonymous question. They're asking, what should a family member do when they suspect that a ward is being abused by a guardian's incompetency?
They need to, number one, they need to, file their complaints with the probate court. That is, if this guardian is governed, if the individual's in the community, of course, Adult Protective Services, I saw that mentioned before, but Adult Protective Services is always an option. APS does not manage people who are in facilities, however. If they are in a facility, every facility in the state of Ohio, there is an ombudsman. Here in Southwest Ohio, it happens to be here at Pro Seniors, but these are resident advocates to protect residents' rights, which includes, avoiding abuse or exploitation. So those are other options with regard to the ombudsman to intercede. But certainly filing a complaint with the probate court in writing is always appropriate. As we sort of indicated, the court is the superior guardian and is ultimately responsible to make sure this guardian is doing what they're supposed to do.
Okay, so we have about 2 to 3 more minutes of Q&A time. So if you want to get your final questions in, put them in the Q&A chat. So we've been talking about how to avoid guardianship using these alternatives such as healthcare power of attorney, financial power of attorney. Just to be crystal clear, what are some of the common myths about becoming a guardian and some of the disadvantages of being a guardian?
So yeah, one of the common myths, sort of like we also see with, someone you've designated in your will, the fact that a guardian is designated in a healthcare power of attorney, does that make you guardian? And the answer is no. You have to have this probate proceeding. You have to declare this individual incompetent. It is frequently, it's just fill out a few papers with the court. And as we've already explained, it is definitely not that situation. That ward is going to have rights. They are going to be served with your paperwork saying that you think mom or dad is not competent and should be made a ward of the court. So it is the last alternative when there are no other, there is no other way to take care of a ward. So I'm sorry, you said common myths and then
disadvantages.
Disadvantages. Sorry, there you go. Disadvantages. Well, disadvantages to the ward, of course, is that their rights are stripped. Okay, they don't have the right to live where they wish. They do not have the right to make decisions on their own, as opposed to both of the documents, healthcare, financial powers of attorney. You don't make the decision of who's going to be in charge of those decisions. Yes, there are cases in which guardians have been appointed and, forcibly removed the ward from their home and placed them in, locked memory units in nursing homes, against their wishes. this is the kind of power that a guardian has. And, you know, the defense is, you know, getting into a hearing to the court to say, wait a minute, I don't need this. Guardians have, you know, prohibited family members and friends from visiting their wards. And again, the challenge then is to go into probate court. With regard to the guardian, again, it's not just paperwork. It is, you know, submitting, you know, doing educational courses, getting approval from the court for everything you spend, filing reports, keeping receipts, you know, producing all your bank records every year. There is a considerable amount of management required for a guardian.
Okay. And then finally, can you just respond to what can people do, or what can people search on the internet if they're looking for guardianship assistance or healthcare power or financial power of attorney assistance in their state?
Gotcha. Yeah, so you can look for, if you Google like Legal Hotline Colorado, for instance, or Legal Helpline Colorado, legal resources for different states, that's usually a good source. And you know, if to some extent, you know, calling our helpline and you're saying, hey, you have something in Virginia, they may have the list if there is one. But yeah, generally speaking, legal helplines for whatever state you're in should pull up whatever might be in your state.
Okay, great. Well, we'll have to let that be our final question.
All right.
Well, thank you so much, Miriam. Always a pleasure having you. Look forward to the next time.
All right.
Good night to you.
All right. Everybody have a good evening.
Okay, so as we close, I want to highlight a couple of ways to engage with AARP. Did you know that a new way for members to experience AARP is by volunteering with us? Earlier, you heard from our wonderful volunteer, Sandy. As an AARP volunteer, you will support family caregivers, help make your home and community more livable for everyone as you age, help prevent fraud, engage voters, and support legislation and policies that benefit the 50+ community. You can also enjoy fun, sporting, cultural, and community events, and even volunteer from home. Many AARP volunteers around the country find volunteering to be a fulfilling experience. So if you're interested in becoming an AARP volunteer in your area, visit aarp.org/I want to volunteer. That's aarp.org/I want to volunteer, and an AARP representative in your area will contact you. And finally, AARP is local, offering meaningful connections and enriching experiences close to home. To find an AARP event near you, visit aarp.org/local. That's aarp.org/local. It's been a pleasure being with you today. In a few minutes, you'll receive a survey about this event. Please complete the survey to help us continually improve our offerings. Thank you for joining us. We hope to see you at another AARP event. Good night.